Today we're going to do a review of the state of ADA or Americans with Disabilities Act litigation in the United States for this year. This is a first part of our presentation. Expect a follow-up in a few weeks. And I'm going to go over first the highlights from the recent release of UsableNet's 2024 mid-year report. So what is the mid-year report? UsableNet produces a document. They've been doing it every 6 months since 2018. They keep track of every federally filed ADA lawsuit for both physical and digital properties. They then filter out any physical ADA litigation, and then they add claims made at the state court level against websites. All information is verified by using comparison with the public record. They are not able to track demand letters because often those are sent privately to companies. And they also additionally categorize the companies that they find in the suits by type of industry. So they get a sense of which industries are being targeted with ADA litigation. And so what did they find? The most active states for litigation are New York and California. This is not different from previous years. So far, at around the mid-year, we have about 2,000 cases. So we're on track to get to about 4,000 cases for the year, which is a slight dip in the numbers. More suits are being filed at the state level, and there have been more demand letters. But in general, plaintiffs' firms like to aim to get settlements rather than proceed to a lawsuit. This helps avoid filing fees, and it reduces the stigma that some plaintiffs' firms are getting for filing cookie-cutter complaints. The reason that more state courts are seeing filings is because many of these plaintiffs' firms are trying to avoid inundating federal judges with these cookie-cutter complaints, as the courts have become more hostile to such complaints with regard to standing. So you're seeing a pushback from New York. State courts may be friendlier than federal court. Some state laws have potential for monetary damages associated with a discrimination complaint. So they're more likely to get additional money than just the filing fees as a result. They estimate about 2 times the amount of demand letters as lawsuits. If the lawsuits track for 4,000 a year, then we're seeing then 8,000 demand letters by their estimate. And this just shows how much the state filings have increased. Previously, they were noting an 80-20 split, so 80% filed at the federal level, 20% state, but that has jumped up to 44% now with state court filings. So more than double the suits are being filed in state court. And they also went into talking about how the plaintiffs' firm, they have a staple of clients that are serial plaintiffs. So they file many complaints. And they also have serial testers. So they have people that are just basically browsing the web, looking at mostly e-commerce websites, and then seeing if they're finding any accessibility errors or problems, or they're unable to complete the task. And if they find issues, they basically make a list that gets sent out to one of the lawyers, who will then send a demand letter out. It becomes like a factory, and that's why they're calling them cookie cutter complaints. They just file as many lawsuits as possible, see which ones stick, which ones they get a response to. They are saying that about 20 firms comprise 83% of the filings. So one thing you want to do when you're looking at a claim is you want to find out, is the claim a federal claim, a state claim? Is it just a demand letter for a particular company? And what they're seeing is that the claims, whether at the federal, state, or the demand letters, they're all similar in what they're saying. But when you have a particular claim, you need to give a different response depending on whether it is a federal claim, a state claim, or just a demand letter. And so you want to know what is the type of claim so that you can hire a firm that specializes in that space, because lawyers' firms will specialize either at the state level, the federal level, or they may be firms that tend to be defense firms for handling these types of complaints. And you want to get the kind of specialist working with your company if you receive a claim or if you receive a demand letter. And the vast majority of these claims are made by visually impaired plaintiffs that are using assistive technology like screen readers who are unable to complete tasks on a website. And a smaller proportion of these lawsuits have to do with audio disabilities who request video captioning. The basis of these claims can be either through use of a scanner that is looking for WCAG violations. It may be because an accessibility overlay or widget is creating a barrier for screen reader users, or they may just be saying, hey, you don't have an accessibility statement. That means that suggests that you might be discriminating against people with disabilities, even though there is no law saying that you need to have an accessibility statement. And this is just showing you the breakdown of the cases. So we're at the mid-year on 2024. We have 2,000 cases, so projected to be 4,000 cases, which would be about even or slightly below last year's number of cases of 4,500. And again, most litigation is settled, and the average cost is about $5,000 to $12,500, depending on the firm and the issues found. So this is a little lower than the previous numbers that they have talked about with regards to litigation. The chambers of commerce are unhappy with these ongoing cookie cutter complaints, and they're starting to fight back on these claims. And so the automatic response now isn't to always to settle. If you have a reasonable reason to fight the lawsuit, then you may see more people going to court, because they are finding that there is some hostility in the courts to these cookie cutter complaints, and they might throw it out on the basis of standing or nexus or whatever. So that's why we're seeing this kind of evening out of the lawsuits, or even a decrease. Typically right now, all that a plaintiff will be able to get, depending, except for certain states, like I said, is that the litigation fees are paid and they will get the website fixed for accessibility. At the federal level, no damages, and then at the state level, sometimes you can get about $5,000 of damages. And what are the states that have things that can result in damages? So state laws, the California's Fair Housing Act, you can get 4,000 damages per injury. And then New York City and New York State, so these are separate laws, have a human rights law that prohibits discrimination in the areas of employment, housing, and public accommodation. If you're building mobile apps, in the past, mobile apps have been a very small amount of these lawsuits, but again, these cases are now rising. So if you are a mobile app business, then you may want to take that extra step to prioritize making sure that your mobile app is accessible. We are going to continue to see these types of lawsuits become more frequent. What are some of the filing trends? So there are certain states where you will see more filing, and those 3 states are New York, California, and Florida. Why? So New York and California have a lower barrier of entry with regards to standing in state court as compared to federal court, and the federal court in California, again, is less friendly to cases with regards to standing. The judges are unhappy that these cases are clogging up their court docket, so they're just getting upset. And so that's why they're moving to the state courts that are friendlier. And what exactly is standing, if you're unfamiliar? So when you file a lawsuit, standing is whether you have the right to be the one to file that lawsuit because it is something that affects you, that you have a reasonable reason for being the plaintiff in the case. And what we're seeing is that they don't want to just see that you're some sort of tester, that you really didn't have any interest in buying anything from the website, that started testing it, you found a problem, and you really don't have a reason to revisit the website. You're really not. So what they're wanting to see is that plaintiffs are actual customers who are trying to do actual business, and they're failing to be able to do so because of the barriers on the website, and that's why there's a court case. Florida cases are always federal because there is no state court to handle these types of cases. Just to clarify, if your company is not headquartered in New York or California, it still can mean that you can be sued in these states, because if you provide services in these states, so your website is like anybody across the country can buy from your website, you are subject to be sued, because if there is a New Yorker or a Californian who has a visual impairment, uses a screen reader, and is unable to use your website, then they can sue you in New York or California, even if your headquarters is not in those two states. We're also seeing more lawsuits just about the inability to access information. In the past, e-commerce was the primary target, so the ability to do a transaction on a website, to purchase something, when there were barriers to that, those are the majority of the lawsuits. But we are also seeing now just, I'm unable to go to your website to get the information I need type of lawsuits. So those are increasing, again, in New York and California. Some websites have really significant barriers, especially for screen reader users. The reason we're seeing a rise in these types of lawsuits is it's part of advocacy to try to enforce equal access to public accommodation, Title III of the ADA. They want to force remediation. They want to force websites to take this issue seriously and fix their websites. It's not like people are going to the business first to say, hey, I'm trying to get information on your website. Can you please fix this? What you're seeing is the first contact is actually a lawsuit. So many companies are getting caught flat-footed on this issue because they haven't been thinking about accessibility, and all of a sudden they're being sued. Nobody contacted them ahead of time to give them an opportunity to fix the problem, and that's what's upsetting the business community. Company size doesn't matter. So you could be a large company, you can be a small company. The lawsuits against smaller companies are increasing, and especially against fast-growing startups, because these types of businesses tend to ignore accessibility. They're more interested in their growth, and they think that's something they can address later, and they're running into problems. What are the industries targeted for litigation? So again, e-commerce is a huge target. Number one, 80% of lawsuits filed have to do with an e-commerce issue. They're not the plaintiff is unable to complete some sort of transaction, buy something. So e-commerce is still a huge target. Second is food service, so any sort of food delivery, any sort of food ordering, things like that. The education space has always been a big target, so higher education, college and university websites, and then also entertainment, streaming companies. Netflix was involved with a big lawsuit a couple years back, and then finally travel and hospitality round out the rest. Why is e-commerce such a target? Because most websites do have an e-commerce component. These types of sites are more visible. It's easier to find barriers for a screen reader user to not be able to do something. E-commerce sites tend to be more complex because they involve payer portals. They send you places to send in your credit card information. There are a lot more forms to fill out to make a purchase. And every time there's a complexity added, they're more likely to find a barrier or a problem. And e-commerce sites are constantly changing because they have different inventory from day to day, sometimes month to month. Some are really changing their inventory a lot. If that new product that was just put up on the site with a photo doesn't have the alternative text added, it becomes a problem. Media tends to be a big issue. Is there alternative text on all your photos? Are you captioning your videos? Are you transcribing your audio? Are you transcribing your videos? We have a lot of serial testers that are out there looking for e-commerce sites that fail. Accessibility overlays and widgets are another issue where we're seeing rising litigation. So many of these companies say that if you put our widget or overlay on, you are helping the disabled and you are reducing your risk for a lawsuit, but this is just really not true. Widgets in general only fix about 70% of the accessibility problems that could be possible. They can't address everything. They're being sold to businesses as a simple, cheap solution, in some cases increasing their likelihood of being sued because everybody knows the widgets aren't really living up to the hype. And they aren't doing everything, especially for the blind, especially for screen reader users. Some screen readers are not compatible with the particular widgets that are being put on sites, and it just completely blocks them, and then they get sued. And especially if your website is complex. So if you have a complex website and you're relying solely on an accessibility overlay or widget to provide all your accessibility solutions, this will eventually get you into trouble. Both demand letters and lawsuits are increasing in this space. If you want to go this way, then you should make sure that the company that you hire that's making the widget for you or doing this accessibility overlay is doing full compliance tests. Make them certify that what they provide for you makes you WCAG 2.1 level AA compliant, and that they will indemnify you if you get sued. Request proof, something in writing, because if they really think that their product is going to be enough, then they should stand by it. Because even though some of these widgets offer litigation plans, in the end, what they're finding is a lot of the companies are basically overstating what they're doing for the business, and then the business gets into trouble. Inaccessible third-party payer portals is another problem. So most people don't handle their own payer portal. You contract with a third party to provide that. Examples of third-party payer portals are things like Stripe, PayPal, things like that. So you want to make sure that these third-party products are accessible, because you, as the website owner, are responsible for third-party products that you decide to put on your site. And if they're not accessible, if the screen reader user can't go through the purchase process all the way to the end using the third-party payer portal, then that can get you in trouble. So make sure that if you're going to add a third-party product to your website, that you've asked that company whether their product is accessible. What are they doing? Do they audit themselves on a regular basis to know that their new features are accessible? Things like that. And especially if you're going into contracts with vendors, like multi-year contracts, because we'll see later when we go over some of the litigation and regulations that there are deadlines to these regulations. And if you've signed, let's say, a long contract with a third-party payer and they're not accessible, and then you find out you need to meet a deadline, then you might have to exit that contract early, and that's going to cost you because you'll have to find somebody else to take that role on. So now we get to the section where we talk about some of the important cases that are affecting ADA law. We go first to the Southern District of New York for the Martin versus Second Story Promotions case. And this goes back to the question of whether a plaintiff has adequate standing to participate in a case. And here, in this case, the person who put the suit forward really couldn't explain themselves in any way as to why they were on the website, what they were trying to accomplish, and what they were doing, whether they had looked at other websites to see if they could get their issue taken care of with competitors. It was clearly a carbon copy complaint where the person was really a serial tester, and they weren't a true customer of the company. They weren't trying to accomplish a particular thing that they were unable to accomplish, and the case was basically thrown out on an issue of standing. The judge had actually looked at their docket and found that the same firm had filed 9 cases in the same court that were similar, in the case of a firm just clogging the docket, and the judge did not feel favorably towards this and threw the case out that they didn't have adequate standing. This just goes to show that this is becoming a big issue with the courts, that they want these types of ADA lawsuits to have real merit before they will hear them out. And the next case, again, was something similar. It was Felix versus iHealth Labs, also in the Southern District. And the judge, again, was not convinced that this was anything more than a cookie-cutter allegation. The person wasn't very clear on why they were looking for COVID-19 tests and couldn't really explain what they were doing on the website, why they were there. It didn't seem that they needed the tests for a particular reason. So again, it just seemed like another case where the plaintiff was some sort of serial tester and not a true customer of the business. Now, in the Western District of Pennsylvania, it's actually a court that's a little bit more favorable for plaintiff's claims. There's one particular firm that tends to file here, and they actually will put some sort of cover letter with their case that will discourage their cases to be thrown out on the basis of standing, because they'll have a list of previous cases showing that they do have standing or whatnot, or how what they are alleging shows that they have adequate standing. So the Western District of PA is still a more favorable court to hear cases. Murphy versus Spongell LLC in the Western District of PA was actually, rather than being dismissed on the grounds of standing, was dismissed on the grounds of nexus. In this case, visually impaired individuals were trying to purchase items from the website and they were unable to do, but because the company was solely a internet-based business, they had no physical nexus. They questioned whether this really fell under Title III, where you consider businesses that are considered public accommodation fall under Title III of the ADA. In this case, because the business did not have a physical location, the judge felt that it didn't really qualify as a Title III case of public accommodation, which was different from previous cases where they did in fact rule that an entirely internet-based business could still fall under Title III public accommodation. I believe that was the Blue Apron case. So in the past, there was a different case in a different court where they did say that internet-only businesses did fall under Title III. So this is an area of controversy and can be interpreted in different ways. So they dismissed this on the grounds of nexus. So how is this going to affect legal trends? Basically, if a company that gets a complaint is able to get the case thrown out on the grounds of inadequate standing or lack of nexus, that will be something that they will try to do rather than automatically settle. And that may discourage more of these cookie cutter complaints, because those are basically filed hoping that they can get a quick payout. So if that is something they can't do, because companies are more willing to go all the way to court and then try to get it dismissed, then it may not be worth it for them to continue in this avenue of cases. And there was an opportunity for the Supreme Court to actually rule on whether serial testers are considered to have standing with the Atchison Hotels LLC versus Lawfer. And this was a case where the person the plaintiff admittedly was a serial tester and was just checking hotel websites to see if they worked for people with disabilities, if the person was able to adequately get through the booking process on the website. And in this case, this was set to go to the Supreme Court for ruling, and this would have had wide-ranging effects if the Supreme Court decided that serial testers do have standing or they don't have standing. But in the end, it never got in front of the Supreme Court because the plaintiff lost legal representation prior, and the case was voluntarily dismissed. So unfortunately, we still do not have any sort of clear case law about whether a person who is clearly a serial tester, not a true customer, has the ability to have standing to be a plaintiff in these types of lawsuits. In the states, there are some laws that are either in process or already active that need to be kept an eye on. So in California, there is AB 1757, which is proposing that WCIG 2.1 level AA as the level of accessibility that websites and mobile apps must follow. This is not groundbreaking. This is already something that has been adopted by the new Title II regulations that the DOJ released earlier this year, so that state and local governments need to comply to this standard. The way California AB 1757, though, is different is because it expands liability to third-party developers and gives people with disabilities and businesses the ability to sue web developers for creating the websites that do not conform to the standard. So in the past, the web designer, web developer was not usually someone that could be sued directly. The business that hires the contractor was ultimately liable for any problems on their website. But in this case, if we open up not only the business itself, but the third parties involved, that really broadens the scope of who can be sued for a website that isn't accessible. And in this case, plaintiffs could recover more damages. And so this would, if this passes, this will have wide-ranging effects because many platforms that people rely on to build websites aren't actually fully accessible. And so if those companies are now also liable, in addition to the business itself, that will have significant effects. And then also, of course, individuals that do web design, individuals that do web development will need to be better about their knowledge and ability to build accessible websites. In Virginia, we have HB 1355. It's proposed that public institutions pay for someone to do an accessibility conformance report. This bill was postponed to 2025. The concern with this is the added expense that an institution or organization would have to pay to hire some sort of certified company to do a report as to whether their site is accessible. So first they would have to also lay out what are the credentials of the people that can do such reports. What do they need to be? Do they need to be certified in any particular way to have the expertise to say that a website is conforming to a particular accessibility standard? And then they have to be responsible for the report saying that the site is accessible. So there's a lot of added expenses involved. Who's going to pay for that kind of report? And also vet people who are considered experts enough to make such reports. And so the concern about this is, how is this going to be paid for, and is this something that's really scalable to have everybody have to prove this and create these reports? So now that we're pushing with this idea that websites have some sort of official seal that they conform or comply, this is going to affect government contracting. So this year, the Department of Justice released clarification on Title II that affects state and local governments, that anyone basically doing business with these entities has to create products that are accessible. And so what this means is that governments are going to put accessibility as a requirement of doing business with them in their master service agreements. So anybody who works as a government contractor is going to have to make sure the service they provide or the products they provide are accessible. Otherwise, they will not be able to work with the government's entities under Title II. And then internationally, because of the recent rulings with the EAA, the European Accessibility Act, there will be a minimum standard that you have to meet to do business with the EU. And that, again, is WCAG 2.1 level AA. And each country can create stricter laws, but there is a minimum standard. So the EA sets the minimum standard that all the member countries within the EU must follow, but each member country can choose to be stricter. And they also have to decide what kind of enforcement. So each country can basically generate their own fine system or liabilities. One country may say that you can't do business in their country at all, or you get suspended. A country can put fines, and that fine level may be different from country to country. So depending on your market, whether you're trying to do business in all of the EU or in certain member countries, you're going to have to understand all the laws individual to each country that you want to do business in. So they're also seeing new trends with settlement agreements. Basically, it's not just remediation requests, and it seems that a majority of cases get settled within 3 to 6 months. So in addition to making sure your website is actually remediated to WCAG 2.1 level AA, they're actually seeing a lot of other requests from the plaintiff, and that's something that it doesn't mean you're going to have to do all of these things, but they will be negotiated in your settlement. But basically, they are requesting more and more things. So, in addition to remediating the site, you might be asked to post an accessibility statement. You might be asked to control your third party content and make sure that the third party content is accessible, including payer portals. You might be required to do accessibility training for all your personnel in customer service design and development. You might be asked to do monthly accessibility audits, so continual testing, and then quarterly accessibility testing as well. And then names, they might request also the names of the developer that's building the site and insurances that developer moving forward is also going to fix any bugs that are found in future with regards to accessibility, and the ability to come back to your website to retest it for compliance under the settlement agreement. Defense lawyers may decide that they don't want to make all of these concessions, but these are some of the things that they're seeing proposed in settlement agreements. And another interesting thing that came up was how you should update your terms of service and make sure that your terms of service is screen reader capable, and to include two things that are suggested. One is a strong arbitration provision and also a class action waiver. These two things will serve as a deterrent. When plaintiffs see that you can move to dismiss a complaint or threaten to move to dismiss a complaint on the fact that rather than going to court, you're going to go into arbitration. And then you should also possibly also add a clause requiring ADA compliance for anything that your company is buying. So like when you're setting up contracts with vendors, that you should add a clause about accessibility so that the products that you get from your vendor are also accessible. And another interesting area was that they went through was how to handle a complaint. First and foremost, don't ignore any sort of complaint that you receive, even if it's just a demand letter, because typically once you get a demand letter, if you do nothing, within 60 to 90 days of getting a demand letter, you will get some sort of filed complaint. So once you get a demand letter or any sort of complaint, you should speak immediately with counsel to discuss how to handle it and what strategy you will employ. You should get an accessibility expert to test your website and list out what is not compliant with both WCAG 2.1 and 2.2. Then you should look at the complaint, do some research on the plaintiff. Are they a known serial plaintiff? If yes, then discuss with counsel whether you have any sort of argument to move to dismiss on lack of standing. And if you plan to settle, then make sure you have a good accessibility remediation company to work with you. You should weigh the monetary cost of both approaches, whether going to court is your better option or settling. Think about whether you have more than one brand, because if you've gotten a complaint with one of your brands, it's likely you're going to get a complaint with another brand, and you'll actually have multiple websites involved in your case. Consider that and understand your nexus. Do you have a physical location? Will you have any sort of grounds to dismiss on nexus? So understand nexus. And is your website simple or complex? Because of course a complex website will be harder for you to get remediated properly. It'll be more expensive and involve more things. Do you have an accessibility statement? If you don't, then put one on your website. It can be a broad statement that you believe in accessibility, that you know it's an ongoing process, that there should be an easy way for you to be contacted for these particular issues. And you don't really need to talk about specific standards, but you can just make a broad statement. And are you using an accessibility overlay widget? Is that really adequate? Is that something you should be continuing to use? Or is that really just going to be something that they can add to the lawsuit as something that's not helping people with disabilities? And then once you have your list of things that are wrong with your website, if you have an internal development team, contact them to fix any issues. If you don't, then you need to hire a company to help you. And you may also want to hire a company to do user testing with a screen reader to see if there are any additional barriers and focus on whatever those barriers they find. And then you need to give notice to any of your vendors that they will need to start providing you resources that are accessible moving forward. Add that clause to your contracts, and if your vendor cannot be accessible, then you may have to look at exiting out of a multi-year contract, finding a new vendor, etc. So these were the key things that were talked about during the UsableNet's mid-year report. I think there was a lot of good information from many companies, how to handle a complaint that you get, making sure your terms of service has addressed certain things that make you less likely to be sued, and also idea of adding an accessibility statement. Last year when we were talking about accessibility statements, it was definitely more of a less important to do, because there were some concerns that if you put something into your accessibility statement in some countries, if you do and then you don't follow what you're saying, you could actually be sued for that. So there were questions about whether putting an accessibility statement was a good idea or not. But it looks like this year it's leaning towards, yes, you should have an accessibility statement. It doesn't need to be a very specific statement, but it should be there. And I think with the way cases are going, you may see less settling and more attempts to get cases dismissed on nexus or standing. And then if you do any sort of contracting or any sort of international work, then you need to keep in mind that these new regulations are going to affect you, and you need to make sure that you're able to do or provide services or create products that are accessible. And then there are state laws that we need to keep on continuing to follow that may have broad ranging effects on everybody, and we still have to keep on track with what's going on in the federal and state courts. And if you're in particular industries, then you need to take more care. So any e-commerce business really has to start, if you haven't done anything at all about accessibility, you definitely need to be looking at it today. And then if you're a mobile app developer, it's only a matter of time before we get to mobile apps. So be proactive and start looking at the accessibility of your mobile app today. We're still on track to see around 4,000 cases this year, and we're seeing a move to state courts because they're more favorable than the federal courts. So that's our update on UsableNet and their mid-year report. If you have any questions, feel free to contact me, and I will also put a link to the actual report from UsableNet, so if you want to review the report yourself or attend their talk yourself, then you have the access to do